The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and His Honorable Court.
Mr. Hughes, you ready? Yeah.
Mr. Chief Judge, Your Honors, and may it please the Court. Matthew Hughes on behalf of Donald Melvin, who asks this Court to reverse, vacate his sentence, and remain for a new sentencing without the ACCA enhancement. This Court should do so following Hodge and Winbush, which held that the government forever forfeits ACCA predicates that it fails to timely raise. This Court should not follow Dix and Rumley, which were wrongly decided in conflict with Hodge and with Winbush, and failed to deal with the bulk of those cases' reasoning. But first, Your Honors, the appeal waiver is a threshold issue, so I'll turn to it first. And here again, ironically, the government has forfeited this argument by failing to raise it in a timely manner. No court has said, this court certainly has not said, even in an unpublished opinion, that the government cannot raise the appeal waiver in its first substantive response. The government's first substantive response was docket number 25, a motion for summary affirmance where the government specifically argued the merits.
This was a Rule 27 motion?
Correct.
Okay.
Yeah, the local rule, Rule 27, provides that a motion to dismiss has to be made within the time for
Right,
filing
I just want to make sure I
response.
got the right case.
Correct. So we think that because the government filed its first substantive response without raising the appeal waiver issue, despite knowing that the argument made in Mr. Melvin's first merits brief in this case fell squarely within the appeal waiver, the government has forfeited that argument. But that's not the only reason why the appeal waiver doesn't apply here. We believe that the exception for unknown future government misconduct applies here as well. Mr. Melvin could not have known and did not know at the time he entered his plea that the government would later violate Hodge during sentencing, and that constitutes government misconduct. We raised this in our briefing on the motion to dismiss, and the government has not contested that what it did in trying to circumvent Hodge did in fact constitute government misconduct.
So there's also, your client filed a pro se Anders brief, maybe that was canceled, and the government responded with another substantive motion, but without invoking the appeal waiver. Is that also a grounds to negate the invocation of the appeal waiver?
We think so, Your Honor. And this goes back to the Ashford case. We also cited the unpublished Strong, Surratt, and Myers cases. The best case for the government is, I believe it's the Strong case. In that case, the government was permitted to, raise the appeal waiver because it hadn't filed anything until its first substantive response was due in response to the Anders brief. But here, the government filed a substantive response without invoking.
Either one, I see.
Correct, either one.
Okay.
And then just briefly on the appeal waiver, we also believe this fits the firmly established constitutional right exception that this court has recognized even when an appeal waiver would otherwise apply. But turning to the merits, we believe this case falls squarely within Hodge. And we just have to be candid and admit that we think that Dix and Rumley were wrongly decided and that this court should not follow them. Dix and Rumley failed to deal with the bulk of Hodge's rationale. Hodge was not just about notice and opportunity to respond, and not just about the fact that the burden of proof shifts on collateral review. Hodge was about much more. Hodge said that there were other concerns that should prevent the government from raising tardy PSR objections without good cause, especially when the consequences are so great as an ACCA enhanced sentence. One of those reasons is that it prevents sandbagging. If the government thinks it gets a redo, it can hold ACCA predicates in its back pocket and pull them out later only once it has lost. A rule allowing the government to raise new objections in this case would also encourage lax advocacy, which, relatedly, as Hodge pointed out, does not help the district court conduct sentencings based on accurate pre-sentence reports. Now, there's a tension here, and the rules, the procedural rules that allow for forfeiture and waiver and that require both parties to follow an orderly schedule of providing their objections to the court to the other side balance accuracy and efficiency. If accuracy is elevated above all else, nobody would ever get sentenced. But if efficiency was prized above all else, then we would suffer too much inaccuracy. A rule that requires the government to submit its objections timely, or to have good cause for its failure to do so, is a rule that encourages accurate sentencings and accurate pre-sentence written reports. If people think they get a redo, they're less likely to be thorough the first time around. So, in addition, this is perhaps the most important point about Hodge. Hodge said it's just not fair to hold the defendant's feet to the fire and not do the same for the government. We've cited in our brief several examples of cases where district courts in this circuit have refused on resentencing to allow defendants to raise arguments they reasonably should have raised earlier. And then this court has affirmed that decision by those district courts. The government should be held to the same standard, and that's what Hodge said. Hodge said, we see no reason to hold the government to a different standard.
Hodge was a 2255 case, wasn't it?
Yes, sir, a collateral review
And
case.
so we're here on direct appeal.
Correct.
And your client got notice and a continuance and a new PSR. Isn't that notice and the opportunity to be heard that wasn't present in Hodge, was present in all these other cases?
It's not the notice that Hodge said he's entitled to. True, it is a form of notice, and it's a form of opportunity to
Well, he
respond.
hadn't been sentenced yet, right?
That's right. But the government's premise is that a resentencing fixes everything. That's their premise, that if you just resentence Mr. Melvin here or Mr. Rumley and Rumley, Dix in the Dix case, if you just do a resentencing, then the defendant has notice and an opportunity to respond. But the same is true in Hodge. On collateral review, the defendant had notice and an opportunity to respond at the district court before Hodge went up to the Fourth Circuit. And the Hodge court said that's not enough. That's not the kind of notice he was entitled to. So, just because you can do a resentencing, whether before you ever get to a 2255 stage or after you've gotten relief on 2255, the fact remains you haven't got the notice that Rule 32, the rule requiring objections within a timely manner requires both the defendant and the government to provide. And not just that, but regardless, you still have the sandbagging concern. You still have the lax advocacy. Frankly, the government in this case should have known that there were additional ACCA predicates and should have raised them. It failed to do so. It kept it in its back pocket and pulled it out for later. And that's a Hodge concern. And that's, again, I do want to emphasize this very clearly. Dix and Rumley did not deal with that issue. Dix and Rumley said Hodge is only about the shifted burden of proof and notice and an opportunity to respond. Well, first, the notice and opportunity to respond identified in Hodge is timely notice, which we didn't have here. And second,
Why not?
there wasn't the government failed to timely notify the defendant. Now, yes, he had an opportunity to go back and consider this objection, and then there was a new sentencing, but that just falls into another of the Hodge due process concerns, which is that the government gets to implicitly tell the
I thought he had not been sentenced at all.
Mr. Melvin has been sentenced.
I know, but when this issue came up, had he been sentenced at that time?
No, no, sir. So, but nonetheless, it's just another redo. It's another one of these arguments that a redo makes everything okay. But Hodge said that when the government...
How can you redo something that hasn't happened?
I take your point, Your Honor, that in a sense, it's not technically a complete redo because the sentence hasn't been issued, but it's another shot at the sentencing hearing with brand-new objections. And again, this is a situation where the government was allowed to implicitly tell the defendant, don't worry about all these potential ACCA predicates, we're not relying on them. Hodge said that's a due process problem. It allowed the government to sandbag. It allowed the government to be lax in its advocacy. Those are concerns identified in Hodge that Dix didn't deal with, that Rumley didn't deal with. And yes, this is not a collateral review case. Rumley was not a collateral review case, or Dix was not. Rumley was a collateral review case, but Dix was not. And it's fair for the government to point out, as I'm sure they will, that that is technically a distinguishing factor. But as this court has pointed out over and over again, in Gibbons versus Gibbs in 2024, in Taylor in 2019, and in U.S. versus Brooks in 2008, panel opinions don't just apply on their facts. They establish rationales for their decisions. And a later panel can't just reject underlying rationales for a decision and say, well, it's a little bit different over here. As this court said in Gibbons versus Gibbs, quote, the rule that one panel cannot overrule another would be weak tea indeed if all a later panel had to do was identify a fact, a theory, or an argument that a previous panel did not address. And Dix and Rumley just simply did not deal with these additional due process concerns that were raised and addressed in Hodge. I do want to point out Winbush. Winbush is an important case because it takes the Hodge rationale and it puts beyond dispute that the appropriate remedy is a remand for a resentencing without the enhancement. That's in a published opinion that predates Dix and it predates Rumley, and it completely contradicts the government's argument that if you just do it all over again and the defendant gets another chance to object to these brand new ACCA predicates, that fixes the problem. So that's our argument on those points. I do want to point out several other cases that followed Hodge. Hodge and Winbush don't stand alone. This court applied Hodge in the Benton decision, in the Cornett decision, in the Al-Muwakkil decision, and in several other decisions. So we just contend that Hodge and Winbush are the previous controlling precedents. They've never been overruled by an en banc panel of the en banc court or the Supreme Court of the United States, and their rationale is controlling. If there are no further questions, I'll reserve the rest of my time for rebuttal if I may, or stand on my 5 minutes.
Yeah, you'll stand on your 5 minutes.
Thank you.
Mr. Hughes, thank you.
Thank you.
Counsel, Ms. Roberts.
May it please the court, Tori Roberts on behalf of the United States. Defendant Donald Melvin validly waived his right to appeal his sentence, and this court should hold him to that bargain. I'd like to begin with the point regarding the timely invocation of the appeal waiver here. The government invoked the appeal waiver within the time for the filing of their response brief with respect to the one and only operative opening brief that's at issue in this appeal. Melvin previously filed a different opening brief, and the government responded to that with a motion for summary affirmance. I think as the fact that we're here today arguing this case with an appeal waiver shows, invoking an appeal waiver is not always the most expeditious and efficient way to resolve an appeal. And here, Melvin was raising an argument in those earlier briefs that was squarely foreclosed by Supreme Court precedent. So the government thought the most expeditious way to resolve the appeal and get the benefit that it had bargained for with the appeal waiver was to file a motion for summary affirmance. Mr. Melvin then decided he wanted to scrap his prior appeal, get new counsel, and begin his appeal anew. This court granted Melvin's motion to strike his prior briefs and allowed him to start his appeal over. It would be profoundly unfair if Mr. Melvin was permitted to completely change the nature of the arguments he was raising, but the government wasn't permitted to change the nature of its
What about the Anders
response.
brief, I think, that came in between those two?
So the Anders brief that was raised, that was filed, after that, his defense counsel then
And the
filed.
government moved for summary dismissal. right?
Excuse me, I'm sorry.
Government moved for summary dismissal of that.
In response to the Anders brief, I believe actually what happened was that then his counsel filed a brief as well, I think, and then his counsel, he filed the Anders brief. The government allowed him to file a counsel brief with respect to the impact of Erlinger, and in response to that, his counsel said, there's no non-frivolous Erlinger claim, and that's when the government
But
filed
the
for
government
motion
asked that it
for
be
summary affirmance.
summarily dismissed under the rule and did not invoke the appeal waiver. I thought we had cases that said if the government chooses to respond to an Anders brief, that starts their clock.
But I think those cases are distinguishable because there it was the Anders brief was filed and then the government, responded and then the case continued on based on that Anders brief. Here, the prior briefs that were filed have been completely wiped out and he is beginning his appeal anew. And so what Rule 27 says is that the government needs to file a motion on procedural grounds.
That put you all on notice at that point that he's challenging this ACCA. Even though it changed somewhat as to what he was, I guess, particularly challenging, but you're on notice that that there is a challenge.
Yes,
Yes.
Yes, that's right. Again, the time that he filed those briefs was prior to this court's decision in Lubkin, which made clear that an appeal waiver challenging an ACCA enhancement doesn't fall within the miscarriage of justice exception for a sentence that's outside, the bounds of a legal sentence. And so I think at that time when he filed those briefs, defendants had argued, if I'm challenging an ACCA enhanced sentence, that falls within the miscarriage of justice exception. Lubkin, after the fact, made clear that that is not the case. But I think the government, understanding that invoking the appeal waiver might encourage and invite more litigation, that the best way to resolve the appeal based on the specific claims that Mr. Melvin was raising was to file a motion for summary affirmance. Moving on to the other aspects of the questions regarding the enforceability of the appeal waiver, if the court does decide that the invocation of the waiver was timely here, if you review the plea colloquy, the district court amply notified Mr. Melvin that he was waiving his right to appeal his conviction and sentence. And that's at JA 62, where Mr. Melvin confirmed that he understood the terms of the plea agreement, the fact that he was potentially subject to the ACCA enhanced sentence, and that he was agreeing to waive his right to appeal that sentence.
At that time, he knew what the government was challenging in terms of the prior convictions too, right?
He did not. So at the time of the plea colloquy, the PSR had not yet been prepared. So certainly in plea discussions, the parties had discussions that was under the impression that he would be subject to the ACCA enhanced sentence, but the PSR had not been prepared that identified the specific convictions that were at issue. So certainly if Mr. Melvin wanted to bargain with the government for the ability to raise certain challenges to his sentence depending on what happened at a future sentencing, he could have done that.
And you could have put in everything you had that would justify enhancements too, right? Prior convictions. The government could.
At the time of the plea colloquy?
At any time, yeah, you could have put it in, right?
We could have, but we were not required to do so at the time of the plea colloquy. The defendant is entitled to the notice and the opportunity to respond with respect to those prior convictions prior to being sentenced, and that was upheld by the procedure here. So the government was not required to identify the specific prior convictions at the time of the plea colloquy in order for the appeal waiver to be valid.
But between that time, before the sentencing hearing date, you knew, right?
Yes, that's right. And unless there's any further questions on the appeal waiver, I'm happy to turn to the merits of the Hodge issue. I think that's kind of what your questions are getting at. So here, the governing standard is Rule 32. The government was permitted to raise an untimely objection, and then it was within the district court's discretion to decide how to respond to that.
But 32F says you have for good cause. What was your good cause? What good cause did you all give at the at the time of the hearing?
Sure. So the government explained at the time of the hearing that based on the objection that was raised to the PSR, the government didn't fully understand the nature of the objections that Mr. Melvin was raising. Recall that the PSR initially had 4 predicate convictions that were identified. As this court said in Rumley, it would have been unnecessary for the government to identify.
This case is different than Rumley, because in Rumley, there's this whole discussion about that the government didn't know at the time. You all knew which cases, you knew about the ACCA cases and what didn't apply and what would apply.
Sure. So the governing standard here is, did the district court abuse its discretion in granting the continuance? This court has said that the good cause standard is committed to the discretion of the district court. And the government explained.
But I think there has to be some type of finding as to or at least say what's the good cause. I don't know, based on what my reading of it, what was your good cause, other than it sounds like you all made a mistake.
So the government explained that it didn't fully understand and didn't think it needed to identify another predicate because the specific challenges that were raised with respect to Mr. Melvin's 1989 and 1990 New York State convictions, there had been Second Circuit cases finding that those types of convictions were valid predicates. When Mr. Melvin filed his sentencing memo 1 week in advance of the sentencing, he identified additional cases from SDNY that cast doubt on that because they looked at the specific categorical match about the definition of controlled substances. And so if you look at the sentencing hearing, the government explained, once we saw that and he identified those additional cases, we then came prepared to the sentencing hearing.
But that was in his objections.
That was not in his objections to the PSR. That was identified for the first time in his sentencing memo that was filed 1 week in advance of the sentencing hearing.
But the government did not respond at that time.
So the government sentencing memo would have been due on the same day as the defendant's 1 week in advance of the sentencing hearing. You're right that the government did not file a sentencing memo, but the district court said, in response to the government's explanation of, we are raising this new predicate, but in order for it to be considered, Mr. Melvin would need a continuance and an opportunity to respond. And the district court.
I understand the continuance and the notice and opportunity to respond. My concern is 32F, good cause. I still haven't heard a reason that any good cause was given other than that you all made a mistake.
So the district court's a discussion with the government, the district court said, I want to make sure I get this right, and granted the continuance. So the district court said, understanding that you didn't raise this earlier because the nature of the objection wasn't quite clear, they granted the continuance. I acknowledge that the phrase good cause was not used, but I think you need to look at the context of the back and forth between the government defense counsel and the district court, and it's clear that the district court was, giving credence to the government's explanation of, we did not raise this as a timely objection to the PSR, but now that the circumstances of the sentencing have changed, we want to bring this additional conviction to your attention.
Because you lost, right? You didn't, right, that's you brought his attention because you thought what you had was enough. But when one was rejected and you didn't have what you needed, that's when you wanted that, isn't it?
But again,
Isn't that right? You can admit that.
Sure, yes.
Everything that the government's going to excuse for not raising that appeal waiver, well, it was something else that made it a little difficult. We didn't do that. Now we excuse this. I mean, that's what the Constitution does. I mean, the Bill of Rights talks about all the defendants' things and the Fourth and Sixth Amendment and all those things and right to counsel, but now we're supposed to excuse the government for everything. And I've been here almost over 25 years, and as Mr. Hughes said, I mean, many times when on the other side, the defendant misses sometimes dotting an I or crossing a T. Oh, I'm sorry, you didn't do it on time. I'm sorry, it's too late. But now we're supposed to excuse you for a litany of things. You lost. That's what it was. And you held it back. That's what, and I know it's Hodge very well, I think.
Of course I know that, Judge Gregory,
I know
yes.
that very well. That's what the sandbag pointed. Oh, well, let me see. They have 4 arrows here. I'm going to use these 3. And then I figure out one of the files that's not good. Well, wait, let's have a continuance because I left one at home that I didn't put in the quiver. That's really what this is about, isn't it? Judge Benham said, you made a mistake.
But I think that the rules
Those mistakes
allow for
ought
that.
to do to the benefit of the defendant. That's what the whole constitutional principles are in terms of that sense.
So the fact that Mr. Melvin received notice and the opportunity to respond, you're referencing the Constitution. There was no due process violation with the fact that, of the way that he received his notice and opportunity to respond here.
There's no constitutional value. You're absolutely right. You fall on that. But that's the whole point, though, is that same thing would happen, like I said before. There would be no problem with you if you would give a defendant who made a mistake a chance to do over. You would have to do the same. We don't do that because it's timely, and time is important in the process. And you shouldn't should you get another bite of the apple just because you lost and you calculated incorrectly? You calculated incorrectly on whether or not you should have raised the appeal waiver, all of those things. And now, it's kind of a spilt milk type argument you're making for the opinion.
So the cases that defendant cites in reply about the fact that a defendant is foreclosed from raising an untimely objection, Benton and Ashley, those cases are about district court discretion. So it was not that the defendant was completely foreclosed from raising it. It was within the district court's discretion to decide whether to allow a defendant to raise something that they did not raise previously. That's the same standard that applied here. The district court could have decided, you know what, government, you did not raise this previously. We're here for the sentencing and we're going to proceed without the ACCA enhancement. The district court, in its discretion, decided not to do that.
It allowed it, but the court did that without you putting forth a cause.
So I don't want to repeat the same thing that I've been saying, but I think if you look at the back and forth.
I don't think you ever answered it. You didn't have a cause, did you?
The cause was that based on seeing that there were 4 predicates identified in the PSR, the government did not think it needed to identify another unnecessary predicate, and that based on the objections that were raised and the probation office's response in the PSR, the government thought that those predicates were valid.
Prevent you all from, you're not limited in the number of predicate offenses that you could list, that you could use, right?
That's correct.
Okay, so you could have initially used all 4.
So there were 4, we could have listed 5,
You
that's
could have
correct.
listed 5, yes,
Correct.
you could have
Yes.
listed 5. And I'm looking at the JA, you all already knew, if you look at JA 111 through 12, that that these original objections were there.
So if you look at JA 111
I
and
guess
12,
what I'm asking, when you went in that day, you all already knew that they were objecting to these other 2 predicates.
Yes, I do not dispute that we knew that they were objecting to the predicates. What I was trying to explain is that the government at JA 110 said, 110 to 114 in that discussion that you were referencing said, based on the initial predicates and the nature of the objection that was raised, the government didn't really fully understand the objection that the defendant was making. Recall, these are New York State convictions, it's out of circuit, and there had been Second Circuit decisions that seemed to say that those were valid predicates. But the defendant in his sentencing memo that was filed a week in advance of the sentencing hearing identified some additional SDNY cases that the government then looked at and realized, okay, maybe there is an issue with this predicate. So that was the explanation, was that, certainly, yes, the government was on notice that the defendant was objecting to 3 of the 4 predicates that were identified, but that the government didn't fully understand the nature of the objection that was being raised because the additional cases weren't identified until the time of the sentencing memo.
I think the comment was that in JA 112, we did not object based on seeing that we had already had 4 predicates.
Yes, and I acknowledge that as well, but I think in rumbling.
Which would go to what Judge Gregory is saying, that you didn't object because you thought you were fine with the predicates that you already had. And I don't know if that's good cause to give you a redo.
So I don't think it's a redo, it was a continuance. So I think this goes to Judge Agee's questions to my friend on the.
That's redo system.
Well, it was contingent for what? So you could go back and redo it. So you could go back and add the other predicate, giving him an opportunity. I agree with you, the judge gave him notice. My concern is not the notice after you all failed to object. My concern is the notice, is that you all had an opportunity to object beforehand and you didn't, and then you go and you say, I need a continuance because we need to redo it so we can add this back in. Actually, you didn't ask for a continuance, the judge gave it because she thought that was the appropriate thing to do, to give him an opportunity to respond. You all just wanted to change it on the spot.
That's actually not quite right. What the prosecutor said when they raised this predicate was the defense would need a continuance in order to properly address that as a predicate offense. And if you look at the district court docket, it was docketed as an oral motion for a continuance that was made by the government that was then granted by the district court. So the government made clear in raising this predicate at the same time that they raised it at JA 110, in order for it to be considered, the defendant would need a continuance.
But it wasn't raised until after you lost a motion as to the other two predicates.
That is right. I do not dispute
Okay.
that. Certainly, yes. But I think in order in order for this court to find that that was an error, you would need to be finding that the district court abused its discretion by allowing the government to raise this objection at the time of sentencing. Rule 32 allows an objection to be raised any time before a sentence is
cause.
imposed for a good cause, and the district court.
I haven't heard any good cause. That's what I'm asking you. What is the good cause that you, other than we made a mistake?
So that is the good cause. The good cause is the circumstances of the sentencing changed. It wasn't just that it was a mistake, it was that the circumstances.
What changed? You already knew about the predicate offense. Nothing changed. You already knew about this fifth predicate offense. Nothing changed. It was cited in the PSR.
Sure. So I recognize I only have a few minutes left, so I'd like, if it's all right, I'd like to turn to the issue of harmless error. Because I think here, as this court said in Dix, even if there was an error, we need to look at whether it was harmless. And so even if it was an error for the district court to allow the government to raise an untimely objection, there was no prejudice to the defendant because he received the continuance, he received an amended PSR, he received his opportunity to respond. As his defense counsel said when they reconvened for the continued sentencing hearing, he said, my client would like to raise an objection based on the fact that the government shouldn't have been able to raise this at the sentencing hearing, but the defense counsel said he had a difference of opinion with his client on that issue because he did receive the amended PSR, the opportunity to respond, and the opportunities to provide supplemental briefing. So even if there was a procedural error here, it did not prejudice the defendant. And it was harmless with respect to the procedure that was used for Mr. Melvin's sentencing.
It was harmless, he didn't get more time. In other words, you're saying he didn't get more time because
So the
you
error,
were allowed to get the one more you needed?
so the error you need to look at
Are you
is,
arguing that it didn't have any impact, the fact that you were able to get what you didn't have and decided not to put in, that had no impact on how he was sentenced?
so you
I just
need
want to make
look-
sure if the government is arguing that before us. Is that your argument?
So the argument is the same as it was in Dix. The fact that you need to
I don't
look
want to talk
at the,
about Dix, I'm talking about you in this case right here. Are you arguing that had no impact at all on his sentence? The fact that the door was open for you after your mistake?
I'm not arguing that it had no impact on his sentence. I'm saying
Isn't that the basis of harmlessness?
you need to look at the error itself. The error was a procedural
I need to
error.
look at what? What are you saying I need to look at?
So if we're assuming that there was an error, because we're now talking about harmless error, so assuming that there was an error,
Right, I
you need to
understand.
look at whether it was harmless. The
Right,
error
yeah.
was a procedural error with respect to the timeliness of the notice. And as the court said in Dix, if a defendant, even if the notice is untimely, if he receives the opportunity to.
I don't know if that's necessarily the error. The error is that you all did not get under 32F. There is no explanation or no good cause finding as to why you were allowed to go back and do a redo, which would be different from Dix.
So that is a bit different than Dix, but in terms of, I think the actual error, the error that Melvin is arguing under Hodge is about the notice and the opportunity to respond. And so that's where the fact that he here did receive notice before being sentenced and had the opportunity to respond was harmless with respect to the procedure that was used for his sentencing. I think the issue about whether there was a good cause finding, certainly if there was any sort of question about that, there could even be a remand limited to an explanation of why the district court granted the continuance if you're not satisfied.
So you want another redo too now? Go back.
No, certainly I'm not asking for the remand. I'm just saying if the court was concerned about that, that would be an option.
All right. Thank you, counsel.
Thank you.
Appreciate your
We'd ask the
argument.
court to affirm.
Yeah, thank you. Ms.
Or
Hughes?
dismiss the appeal.
Ms. Hughes, you have anything further?
May it please the court, a few very brief points. The government admits that it deliberately and strategically chose not to raise the appeal waiver in its first substantive filings in this case. That should be dispositive of the appeal waiver issue
Why do you
right
say
there.
strategically? I mean, they had more than they needed and they lost one. How do you say that this is deliberate and strategic?
Ms. Roberts just told you that they were trying to avoid additional litigation on the appeal waiver, and that's the deliberate strategic reason why they didn't include it. They wanted a one and done on the substantive issue, and so she said that's why we deliberately and intentionally and strategically chose not to include it in our first substantive
Right, because she said it would be
response.
messy with all these other New York law and all those things like that.
Correct.
Right, that's what she said, yeah.
You know, additionally, the district court never found that there was good cause, and Your Honor, as Judge Benjamin pointed out over and over again, there's no good cause here except we goofed, we forgot, we didn't bother to raise additional predicates. And the error is not timeliness per se and alone, it is that the government gets to raise a new predicate later on in a situation in which the defendant would never be allowed to. If the defendant were making the same arguments about good cause that the government was making today, the government would be jumping up and down and complaining to the end of the world about how the defendant should have known better and had plenty of opportunities to raise it, et cetera, et cetera. And so we believe that the error is not harmless, and we urge you to reverse, vacate, and remand for a new sentencing without ACCA under Hodge and Winbush. Thank you very much, Your
Thank you,
Honors.
Mr. Hughes. We know that you were court appointed. On behalf of the Fourth Circuit, I want to thank you for your helping us in these cases, difficult cases, and we appreciate it very much. And Ms. Robbins, of course, we recognize your able representation of the United States. We'll come down and greet counsel and proceed to our next case. You may be seated. You may be seated. Go ahead.
May it please the court. Justin Pace, representing the appellant, Dustin Wilson. I'd like to reserve 5 minutes of my time for rebuttal. This case presents a straightforward violation of trial counsel's duty to provide effective assistance of counsel to a criminal defendant. That's conclusive on the face of the record. He did so by failing to persistently and persuasively argue for the defendant's release on bond when the defendant was suffering from ongoing severe dental issues, that the jail where he was being detained was unable or unwilling to provide him treatment for, being deliberately indifferent to his medical needs. That prevented a plea that was knowing and intelligent, because it prevented him from focusing on and participating in his defense at a key time for his defense. Because the record is fully developed, this court can and should vacate Mr. Wilson's guilty plea and sentence and remand for further proceedings. And it's axiomatic that ineffective assistance of counsel claims are typically...
You have no deposition or anything from the defense counsel in this case as to why he did what he did when he did?
Correct.
As you would have in a 2255.
Correct. And these claims are usually better suited for a 2255 petition. This is the rare case that is suitable for determination on direct appeal because we have everything in the record that we need. There was extensive briefing. There were 2 hearings. The defendant provided testimony at those hearings and through a pro se letter, and we have medical records. And while the defense counsel didn't say why he made the decisions that he did. In this case, this court has recognized that a decision cannot be strategic if the decision made no sense. They recognize that in Freeman. The defense counsel's decision here didn't make sense because asking for transfer was never going to be successful. He recognized that he had never asked for transfer in 20 years of practice. The trial court made very clear that it wasn't going to grant transfer, order transfer. It wasn't going to be the ombudsman of the McDowell County Detention Center.
And therefore, his lawyer should have done exactly what?
His lawyer should have argued for release and never should have abandoned the argument for release so early.
And why can we determine that would have been successful in the other side of, Strickland in terms of, harming the harm in the sense that what impact did it have? That we know that likely would have had, that it would have been granted, I think?
Strickland requires a reasonable probability.
That's what I meant. Under that standard, where is the reasonable probability that likely would have been successful had he made the motion that you said he's ineffective for not doing so?
One of the 3142 factors is the physical condition of the defendant. That's what changed from the original detention hearing as he developed these dental issues starting in February of 2024.
I know, but I think that the record is replete with that, but with counsel, you're trying to, he's not a physician, or the counsel's not a physician, and you're trying to get relief, and he's in excruciating pain. So the counsel, well, let's get you removed to some place where they can at least treat you. So here you have a mixture of legal strategy in terms of trying to get you the case, and this is one is what happened while you're waiting. And he made a decision that says, listen, I know what you want. You want to get released. But I think the main thing is you need help. So I'm going to try to get you to some place that gets you help for this horrible pain. To say counsel was ineffective in that's kind of rather kind of harsh in terms of under these facts, isn't that?
Well, Your Honor, I don't fault him for initially asking for transfer or release.
Right.
It was clear at that May 15th hearing that the trial judge wasn't going to order transfer, and unfortunately, at that time, he abandons his argument for release. We see that very clearly in the record at GAA 90.
When he had tried, he did it in the alternative, as you just said. So he needs to continue, even though counsel thinks that's not going to happen, but I do know this, my client is in horrible pain. And I'm going to do my best to get him what he needs physically, because obviously it's not only physical but mental. I mean, anybody who's ever had a toothache or something like that, it'll drive you up a wall. So, but the whole counsel, somewhat Strickland standard, it's kind of difficult on this record. Judge Agee asked a question. You don't have anything from counsel here. That's why it's better suited. It's not better suited. We normally say, listen, unless it's clear in this record, we address it at this point, right? That's why we do it in a habeas form. But I just wonder why you said rather axiomatic that this is wrong. I just don't see that. Help me with that, that the counsel is clearly wrong for what
The timing is important here. We have dental issues that started in February 2024. Trial counsel abandons the argument for release on May 15th. That was before Mr. Wilson had a single dentist appointment. He gets that appointment on May 29th, although the dentist is unable to alleviate his symptoms. The dentist says he needs a root canal, he can't perform it. He needs a crown replacement, he can't perform it. He does get an antibiotic, but that doesn't resolve his situation. He gets 10 days of pain pills, but his pain persists for months. And he's advised to floss, but the jail doesn't allow that. Trial counsel also didn't provide any medical records until June, so both the dentist appointment where Mr. Wilson's symptoms were not treated and the medical records happened after trial counsel has abandoned the argument for release. Because one of those 3142 factors is the physical condition of the defendant, as time passes and Mr. Wilson's dental issues continue, the factors continue to shift in favor of his release, but his trial counsel is unable to use that for his client's benefit because he has already abandoned that argument.
So I just want to make sure I'm understanding your argument here today, is that because he couldn't get the dental work that he needed, he pled guilty. That's right?
There's evidence in the record this affected his ability to participate in and focus on his defense. For the 8-month period from when the dental issues started in February until he signed his plea agreement at the end of September, we know that he's suffering from these issues and he's in a lot of pain. And his trial counsel says at the trial level that his client is asking him questions about his medical issues when they should be talking about his defense. And his client is asking him, if I plead guilty, will they get me help? So we see evidence on the record that this affected.
But is there anything in the record that says that if he pled guilty that he would receive treatment?
No, Your Honor, although it appears that Mr. Wilson believed that it may, and he was becoming desperate.
And so, because it's not in the record either, is there anything that says when this excessive bleeding or when these issues with his mouth ended? Was it before his plea agreement, before he accepted the plea agreement, or was it after he accepted the plea agreement?
It appears,
I didn't see anything in the record.
It appears to be after. In his pro se letter, which was filed on August 9th, he indicates that the issues are going on in full force. He signed his plea agreement, I believe, on September 30th. In his draft PSR, which was filed in December of 2024, his interview with the probation officer indicates that he's still having dental issues. When he has his sentencing hearing in May 2025, at that time it appears he's had treatment and the dental issues have subsided. So for the entire key period leading up to his plea agreement, he's suffering from these severe medical issues. And I do think that the fact that he was able to get treatment and those symptoms were alleviated after his plea agreement does show that this was something that was treatable. So this is an effective assistance of counsel case under the Strickland test. Mr. Wilson must both show that there was deficient performance and that there was prejudice, both which we have touched on a little bit. The focus for the deficient performance here is initially choosing to argue for release or transfer, but really the key mistake that was fatal that cannot have been strategic was to abandon the argument for release and focus on transfer when it was very clear that that was going to be unsuccessful. And that happened before defense counsel filed any medical records. On the prejudice side, we have to show a reasonable probability that would undermine confidence in the original outcome. Now, he was unable to focus on and participate in his defense because of these dental issues. Had he been released, and there was an additional 3142 factor here with his physical condition, he would have been able to receive treatment. He certainly would have been able to floss. And as this court has recognized in Akande, a better guilty plea can be that better outcome under Strickland. He would have also been able to avoid months of pain and a constitutional deprivation. The government has argued that he got a favorable deal. There's no evidence of that. They dropped the gun and stash house enhancement and the gun charge, but they did that because the DNA evidence didn't tie Mr. Wilson to that location and to that firearm. They also dropped the other criminal charges, but...
They dropped like 8 out of 9, right?
They did. And they did that in return for avoiding the expense and risk of trial. That's very standard operating procedure, and in the federal criminal system. Mr. Wilson continues to accept responsibility, but he deserves an opportunity to be able to fully focus on and participate in his defense in those plea negotiations. We ask that this court vacate his guilty plea and sentence and remand for further proceedings. I'm happy to answer any remaining questions, otherwise I'll wait for rebuttal.
Thank you, Mr. Pace.
Thank you.
Thanks for your argument. Mr. Enright?
Thank you, Your Honor. May it please the Court, Anthony Enright for the United States. I'll start by answering Judge Benjamin's question, although I don't think there's really any dispute about it. In the plea colloquy, the Court went over whether there were any promises, agreements, or representations other than what was in the plea agreement. And the defendant recognized the answer was no, under oath. So I think not only is there no evidence that there was some promise of dental care in exchange for his plea, I think the record affirmatively refutes that. And I think that's practically dispositive of the prejudice prong. But to start, there's no deficient performance here, certainly non-conclusively established, because a reasonable attorney could think that an effort to obtain pretrial release under the Bail Reform Act would have failed. And so counsel was not constitutionally compelled to ask the court to release the defendant based on either his dental care or the prison's response to it. The court had already found that there were no combination of conditions or combination of conditions that would reasonably assure the appearances required or the safety of the community, which is the standard of the Bail Reform Act. And there was a presumption based on his charges that no such conditions would apply. The court held the presumption applies, and even if the presumption didn't apply, I would find that detention isn't warranted. So that was the background he would have been litigating against. And there's really not any basis for release based on even the serious health problems that he was reporting. So counsel wasn't constitutionally compelled to make that argument, and the record certainly doesn't conclusively establish otherwise. And then on the issue of prejudice, Your Honor, nothing in the record suggests, let alone conclusively establishes, either that he would have succeeded and been released, or that had he been released, that would have changed the outcome of the plea process, which is what he needs to establish under Hill versus Lockhart. To my friend's point, there are ways to do that other than establishing that you would have gone to trial if you can show or at least allege a reasonable probability that you would obtain a plea with better immigration consequences or that you've received a more favorable plea. But neither of those things were alleged here. So under Hill versus Lockhart, if you're only alleging that counsel's deficiency caused an involuntary plea, you ordinarily have to show a reasonable probability that you would not have pleaded guilty and would have proceeded to trial. Here, I do think he received a favorable plea agreement. Yes, we received the benefit of his plea and avoided the risk of trial. But if you're talking about what would have happened had he not pleaded guilty, we would not have received that benefit. We would have proceeded to trial on the 8 counts, and he would very likely be looking at a much higher sentence. So I don't think it would have been rational for him to reject the plea. And even if there's the possibility of developing that with allegations and evidence, that's not something the record conclusively establishes. And I think that's dispositive under the applicable standard for ineffective assistance of counsel on direct appeal, which we have here. If the court has no further questions, I'll yield the balance of my time back to the court.
Thank you, Mr. Enright.
Thank you, Your Honor.
Mr. Pace, you have a few minutes left.
May it please the court, just a few points in response to the government's arguments. Regarding the plea colloquy, we agree that Mr. Wilson represented no promises were made. We haven't argued that any were. Our argument is not that any sort of agreement was made that he would get his dental care in return for pleading guilty, but rather that his medical issues left him so desperate that they affected his decision to plea. The trial court was admittedly skeptical of release. The trial judge states at the May 15th hearing, you've got some tough facts here. The trial judge was much more dismissive of the possibility of transfer, though, and this happened at May 15th, that this was the hearing where trial counsel abandons the argument for release and does not yet reflect what we're going to find out later as Mr. Wilson's medical issues continue to persist, as the dentist appointment was ineffective at treating those issues when medical records are later introduced. Again, trial counsel prevented himself from being able to take advantage of any of that on his client's behalf for his client's benefit because he had already abandoned the argument for release. As to the prejudice prong, had Mr. Wilson been able to focus on his defense, had he not been so desperate due to the pain that he was in, we think it is likely that he would have been able to negotiate for a better plea. The preparation of a criminal defense, negotiations over a plea agreement are things that happen over a period of time. And for months leading up to the plea agreement, Mr. Wilson was simply not able to properly focus on his defense because of the dental issues that he was going through. And those dental issues were allowed to persist because of the deliberate indifference to his medical needs by the jail. And they could have been prevented had he been released on bond. I think it is also relevant that if his counsel had been successful, which he likely would have had he not abandoned the argument, Mr. Wilson would have avoided months of pain. That alone is a better outcome, and a constitutional deprivation would have been prevented. If the panel has any more questions, I'm happy to answer those. Otherwise, I'll return the remainder of my time.
Thank you, Mr. Pace. We appreciate your argument. We also note that you are court appointed. On behalf of the Fourth Circuit, I want to thank you for taking the assignment and helping us with these cases, and we're much appreciated.
Thank you, Your Honor.
Mr. Enright, we acknowledge your able representation in the United States. We'll come down, Greek Council, proceed to our next case. Well, we're gonna take a brief.
Okay.
Break.
This honorable court will take a brief recess. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
You may be seated. Mr. Mancini? Yes, you may proceed.
Good morning, and may it please the court. Sam Mancini on behalf of the appellant Preston Mills. The district court revoked Mr. Mills' term of supervised release and sentenced him to 24 months of imprisonment because it concluded that he had committed 2 crimes he was acquitted of by a state court jury. The district court committed 2 reversible errors. First, its factual findings rested on a clearly erroneous premise that the government's key witness gave consistent testimony in state court and federal court. Second, the district court sentence was plainly unreasonable because it failed to address one of Mr. Mills' non-frivolous mitigation arguments. I'd like to start with the factual issue first. There's a lot of facts in this revocation case, but I'm going to try and drill down on the precise, clearly erroneous factual finding. Mr. Mills was accused of strangling and assaulting his then-girlfriend while he was on supervised release during an argument. The report to the police came over a year after the incident, and the testimony at issue here was about what led up to his then-girlfriend reporting the crime, Jessica Rodriguez, Miss Rodriguez. In state court, she testified that she reported Mr. Mills to his probation officer after his estranged wife, Mrs. Mills, came to visit her at her work. And this is at JA 696. She was asked, "What day did you report?" And she said, "The day after Mrs. Mills showed up at my location." That's what she testified to in state court. In federal court, she very clearly testified that the ex-wife, Mrs. Mills, showed up after she had reported Mr. Mills to his probation officer and the police. And that distinction matters because it goes to Ms. Rodriguez's credibility and her motivations for testifying, and the district court did not acknowledge this inconsistent testimony. In fact, the district court said at JA 347, it isn't inconsistent because it's consistent with something she said earlier, and that's just factually wrong. The district court messed that fact up, and it undermines its ultimate finding that Mr. Mills committed the crimes that he was acquitted of in state court. And in particular, I guess we are challenging the strangulation, which is the grade A violation.
What about the text messages, the daughter's testimony, the photographs? The district court seemed to take all of that into consideration.
That's true, but the district court still has to reckon with impeachment evidence of the government's star witness here. Ms. Rodriguez was the only one with personal knowledge of the incident. She's the accusing party, and so her credibility and her testimony is sort of the linchpin of the case for the government. And when there's clear impeachment evidence, the district court, at the very least, has to account for it and take it into account. If it ultimately concludes that the other evidence is more than enough or sufficient, it can do that. But here the problem is it didn't even acknowledge the impeachment evidence. It sort of incorrectly found that there wasn't any impeachment, which again is just wrong if you look at the testimony that she gave, which is in the transcripts that the district court had. And so this isn't kind of a typical credibility case where you're looking at demeanor or the inflection of someone's voice. The district court was presented with 2 transcripts, the state court transcript and the federal court transcript, and was just asked to compare them and got the facts wrong. And so that's something that this court can review, and when a district court makes a clearly erroneous finding like that,
I don't know
it
if the
warrants
district court
reversal.
didn't consider them. I think the district court said that they were immaterial and did not affect Rodriguez's credibility. I believe that's at J 343. In the district court, the testimony the testimony relating to Ms. Mills and her motivations to report Mills was not inconsistent. So I think the district court did consider the testimony and the impeachment testimony. It just didn't It just found that it was inconsistent and immaterial.
So, Your Honor, I think,
Wasn't inconsistent and immaterial.
yes, I think on JA 347, which is where the district court was sort of going through the different impeachment evidence and making a ruling, it said, on the fourth issue, which is the issue I've been talking about, sort of when the ex-wife showed up at Ms. Rodriguez's place of work, which was a Wawa convenience store, he says on JA 347 from lines 12 to 17, he says, well, that isn't inconsistent because it's actually consistent with something she, meaning Ms. Rodriguez, said earlier, that Mrs. Mills had come in earlier than the time she did the singing. Again, it gets a little complicated, but in federal court, she said that after she reported the crime, Mrs. Mills came into her work and was sort of singing and humming a song. But then in state court, she said, Mrs. Mills came in the day before and the day that I decided to report the crime, which seems sort of like it was the impetus or the action that spurred the reporting. So that's a discrepancy, and he's saying it's actually, it isn't inconsistent. So his finding is that there was no inconsistency, which is wrong. And also, there's no evidence that she said, Ms. Rodriguez said, that Mrs. Mills had come in earlier than the time she did the singing. There's nothing in the record to support that finding. That's a clearly erroneous fact. He does go on to say, to the extent there is any inconsistency, it's an immaterial variance. It just recites an event to which anybody could make a mistake. Again, I think that's wrong. The Ms. Rodriguez was adamant in both places that in state court she was adamant that Mrs. Mills came in before she reported, and in federal court she was adamant that she came in after. She was actually asked to clarify on JA 128 whether she reported before, or whether Mrs. Mills came in before or after, and she said she came in after. And then again on JA 143 during cross, she said, did you report to the probation officer after you saw Mrs. Mills in the Wawa? And she said no. So there's a clear discrepancy, and the district court's initial finding was there was no discrepancy.
Well, I think what the district court said is immaterial because is as to the strangulation, whether or not the strangulation occurred or not. What Ms. Mills did and coming into the store, I think the district court says is just immaterial.
I think the district court didn't seem to understand the importance of it because Mrs. Mills and Ms. Rodriguez had sort of an acrimonious history that they both admitted. They did not like each other. They were constantly fighting over text message over Mr. Mills. They actually got into a physical altercation before, which they both admitted to on the record. And so I think in state court, when the jury heard that she decided to report the day that Mrs. Mills came in.
Well, the district court heard all this stuff, right?
It did hear all of it,
And
yes.
so wouldn't that just go to the weight of the evidence when the district court makes its credibility finding?
Well, the district court, I guess, did not acknowledge that there was a credibility issue to begin with. It didn't seem to acknowledge that there was an inconsistency because it said it wasn't inconsistent.
I thought it found the girlfriend, I can't remember her name, but it found her credible.
Yes, it did find her credible, but I guess that's the issue we would raise is that it didn't take into account that she gave inconsistent testimony in state court, that she gave a different version of events in state court. It seemed to dismiss that and say, well, it's not inconsistent. And again, if you look at the record, there's clearly a discrepancy about when she decided to report and the Mrs. Mills, the ex-wife's role in that decision to report. And again, I think here it's important to be careful about something like this, impeachment evidence, when you have a jury acquitting Mr. Mills of the crime, right? There's not the same procedural protections during a revocation proceeding. There's a lower burden of proof. The rules of evidence don't apply with the same force. And so the district court should have been extra careful that it was considering all the evidence. And if there was evidence that the state court jury heard that it didn't, it should have taken that into account and at least acknowledged it when it was reaching the decision, even if it ultimately was going to conclude the strangulation occurred. If there's credibility issues with a key witness, the star witness, the only witness with personal knowledge, the district court has to account for that and at least take it into consideration.
I think the district court did. The district court said that the delay, the district court said that Rodriguez was credible regardless of the delay in her reporting. And the court specifically addressed the delay and observed that it was common in cases of domestic violence. So I don't know how you say that that's not taking it into consideration.
I think the district court took the delay, into the year-long delay, but it didn't take into consideration the discrepancy in the testimony about when the ex-wife showed up at work and what led to her ultimately reporting the crime. And in federal court, she made it seem like it was only Mr. Mills's actions that led her to reporting it, that he was showing up at her work, that he left her a voicemail in May, and then a couple of weeks later, she decided to report him. But in state court, the version she gave was, he did all those things, and then his ex-wife, who the jury knew that she really did not like, that she got into a physical fight before with, showed up, and then that day, she decided to go report Mr. Mills. And so that, again, goes directly to the key witness's credibility. And when you have key impeachment evidence like that, the district court has to consider it. So it did consider the delay, but it didn't consider the impeachment evidence or the inconsistency in her testimony. Even though it was presented to the court, it erroneously found there was no inconsistency. If there are no further questions about the factual finding, I'd like to briefly touch on the sentencing issue. Mr. Mills was on supervised release for an additional 19 months while his state court trial was pending, and so he spent that additional time, and he fully complied with the terms of his supervised release. He had negative drug tests. He was gainfully employed the whole time, and he raised this issue at sentencing and argued that it warranted a lower sentence, and the district court failed to address that argument at sentencing or during its sentencing explanation. I will note that the parties did discuss extensively during the multiple revocation hearings whether it was permissible for the court to extend the term of supervised release, and they concluded under 18 U.S.C. 3583I that it was. But whether it's legally permissible to extend the revocation period past its expiration date is separate from whether under the 3553A factors, the court had to consider that extension in fashioning its ultimate sentence, and whether it impacted, protection of the public or deterrence or something like that. And the court simply failed to reckon with it.
So your argument here is a procedural reasonableness
Yes,
argument. My client had a legitimate mitigation claim. We put it on. District court did not consider it. That's your
Exactly.
claim. It's not a substantive reasonableness.
No, it's not a substantive. We're making a procedural reasonableness argument. And so, and under this court's precedents, they've repeatedly said, there's plenty of cases. We cited some of them, Slappy, Patterson. If the district court fails to address a non-frivolous mitigation argument, that's a procedural error, and it's plainly unreasonable under this court's precedents. If there are no further questions, I can reserve my time for rebuttal, but
Yes, thank you.
thank you.
Thank you, Mr. Chair. Ms. Norman?
Good morning. May it please the court. My name is Olivia Norman. I'm an assistant United States attorney, and I represent the United States in this matter. I apologize in advance for my hoarse and coughing. It's just allergies. I'm not contagious. The first, with regard to the credibility findings by the court, the defense focuses primarily on one, what they say is an inconsistency in testimony. But in fact, the district court went through painstakingly through the transcript of Ms. Rodriguez's testimony, the victim's testimony, at the original supervised release evidentiary hearing, and compared it almost line for line from the transcript of the state proceeding. And in doing so, what the court realized was the original questions that were asked of Ms. Rodriguez was Mr. Mills, the defendant in this case, showing up at her work at Wawa? Did anybody else show up at her work at Wawa? And her response in federal court was, yes, after I had filed the complaint, Mrs. Mills showed up, came back to the coffee area, and was humming a song, and when she saw me, because she was working back there, she started humming louder and then walked out. That was the testimony with regard to a June 11th incident that had occurred after the complaint had been made about the assault. What she had also said, though, at the original testimony, in her original federal testimony, and also in the state testimony, was that the reason why she finally filed a complaint, even though it was almost a year later, or it was a year later, was because Mr. Mills wouldn't let go. She had told him, leave me alone, stop bothering me. And he would continue to show up at the Wawa. And in May of 2022, he called and left her a voicemail. Even though she had his number blocked, this voicemail had come through where he was making statements to her about her oldest son getting arrested, and she was spooked by that because it showed that he was still kind of stalking her, keeping track of what she was going on in her life. So that concerned her. She also said that a family member of his had come in, and that was the day that she had made the report. In state court, she clarified that that family member was Ms. Mills, who had come in. But she did not come back to the coffee station that time. She was at the front, just to the register, had come into the Wawa, went to the register, and left. Now, the district court did not specifically say, this is the transcript page number, and this is where I found this, and this is where I found that. But what the district court did find was there were two different trips that Ms. Mills made to the Wawa. The one where she went to the register on June 3rd, which was the day of the initial complaint, and the one where she came into the Wawa on June 11th, which is when she came back to the coffee station and she was humming and singing. That is significant not because is it material when Ms. Mills came to the Wawa or not. But what is significant is that when it was raised by the defense that there was a possible inconsistent statement, the district court spent hours going through saying, show me exactly where it was inconsistent, and went through line for line and made factual findings. And the district court's factual finding was there were two Wawa trips. And that we see at JA, that finding is at 346 and 347. So the district court, the significance of the whole thing is that Ms. Rodriguez said that Ms. Mills came in on June 11th, or that she came in on June 3rd. In fact, she said she came in both times. What is significant is that the court took the time to go through each and every alleged inconsistency and found, based on his analysis of the transcript, that there were no inconsistencies. He specifically found there was no inconsistency here, and if, in fact, there had been some mistake about the timing of this, it was not significant enough to impeach. I think we also have to look at this, though, in the context of what the rest of the evidence was. Among the evidence, and included that the court considered, was Mr. Mills himself, his testimony himself. When he testified after his state proceedings were through, he then testified in the district court supervised release revocation hearing, in a separate evidentiary hearing. And in that hearing, Mr. Mills admitted to what had happened that night. He admitted that they had gone out for dinner, that when they came back, they discussed the truck, and that he was concerned that she was going to keep the truck because it was in her name. And he confirmed all of that, and even confirmed that he had, in essence, in his terms, assaulted her because he claimed that she had dropped the keys to the truck down her pants and he had to get and grab those keys out of her pants. So he himself admitted that something had happened that night. So it wasn't just the uncorroborated testimony of Mrs. Mills. It was that she said that what happened was that he assaulted her, kicked her, strangled her, choked her. That it stopped when her daughter banged on the door. No one is saying that no one banged on the door. That testimony was also credited by the district court judge. The daughter testified that her mom's voice sounded raspy And she came running out of the room. Then there were this host of text messages. And we can just talk about the text messages in the abstract and say, well, there were text messages back and forth. But when we really read those text messages and what was actually said, she said, we're through. You kicked me, you hit me, you strangled me. We're done. And his response was, sorry, I knew better. So it wasn't just her testimony that the court credited. It was her testimony. It was her daughter's testimony. It was the text messages that were sent in the early morning hours just following the assault. It was also that there was a 911 call that night, and the police showed up that night. She turned him away, said, he's gone, we're done, I'm fine. And she didn't file a complaint.
The counsel, you do a fine job, both of you, in terms of the trial, within the trial, the middle trial, and that. But, the Sentencing Commission is really sad that very kind of rather disfavored about this acquitted conduct situation. And, I think perhaps our founders would sort of roll over in their graves to think that since they put so much detail in the right to account of jury trials and all those fairness, say now we're sentencing people based on what they were acquitted for. It's very disfavored because I know when I practiced law, they said a juror passed between you and court, and therefore they'll make a judgment and then they'll say no more. But now we got a trial now. I don't know. It's kind of difficult because basically you could say, I'm not just hypothetically. I would say the judge said, you were acquitted, but I'm looking at you now. The way you talk to me, and this is hypothetically, I think you did it. That's all that would have to happen. By preponderance of the evidence, I think you did. I've looked over the record in terms of the record trial type thing, and 12 independent people who were sworn to do all those things found you not guilty, but I find by the preponderance you did. That's really all it requires, isn't it?
Well, and
Isn't it?
it is, but that is by law, right? That's 18 U.S.C. 3583, E3. Says that the court shall find by a preponderance of a violation of supervised release. What's required for a conviction and sentence following, and a sentencing for that conviction, right? We have to have a conviction in order, and that is proof beyond a reasonable doubt. And what the Sentencing Commission said was that we're not going to consider relevant conduct, acquitted conduct in federal court, not what happened in state court someplace else. What the guidelines are talking about is including in relevant conduct, i.e. the conduct that you're going to get sentenced on, conduct that you were acquitted of in that federal trial. And that makes total sense because we're talking about a conviction of a crime and what the sentence should be for that offense, that conviction. But in the supervised release arena, we're not actually talking about a conviction of a crime. The question that the court has to consider is, did this person, first of all, was he on supervised release? Did he have a condition? And did that condition get violated? Did he violate that condition? It's not. And it gets a little fuzzy sometimes when we talk about don't commit any more state, federal, or local crimes, because all of us in the criminal justice field are saying, oh, you have to prove a crime beyond a reasonable doubt. That's true. But that's not what this judge is doing.
Well, but in this case, correct me if I'm wrong, y'all had worked something out for 18 months, and I think, right? And they agreed on it, and the court said, no, I can't take this because he may not get enough, this may not be enough. So it was dependent upon, he was looking for a conviction, or not, or a result, right?
Well,
am I right about that? Didn't the court say?
Yes, absolutely, the court does.
So it's dependent upon what happened in that state court.
Yes, but it could have also gone to the other direction as well. And the real reason the judge wouldn't take that was because Mr. Mills felt that he could not he could not plead guilty in the federal court without basically waiving his Fifth Amendment rights. Because if he said, yes, I did it for the purposes of federal court, for purposes of saying, did you violate supervised release or not, he was concerned that that would be used against him in the state court proceeding. So what he was going to do was plead no contest, and the parties were going to agree to 18 months. And the judge did not want a no contest or a nolo contendere type plea to the supervised release violation. But
Why
yes.
not? Why not? That wouldn't have changed what the range of the court could have sentenced him to.
No, it wouldn't have, but I think what it would have changed is that the court would have not heard the testimony and the evidence to know fully all of the factors that the court needed to consider on just how bad was this violation of supervised release. Not how bad was the crime, but how bad was this violation of supervised release.
Well, he should have found not too bad because the court said, the jury said not guilty. That should have helped him.
Well,
instead, it must have hurt him.
Well, but in fact, I mean, we really cannot, I mean, we're talking about separate sovereigns here. We don't know what happened in the state court.
Yes, we don't know.
No, I mean, I'm sorry.
We don't know that he was found not guilty.
He was found not guilty. What I meant by that is we don't know how the case was presented in state court. We know that we don't know how well the evidence was presented. I mean, we have some transcripts, but we also don't know to what extent, was there some jury nullification? We don't know any of those things because it's a separate sovereign and we weren't there.
Well, why were you waiting for it then? Didn't the court know that he wasn't going to be there for the trial? Anyway, all those things you said may be true, but then why wait then?
Right, but that is something that happened in a separate court under a separate
I
sovereign.
know that, but it was tied in this record to it by the court.
It was,
Yeah.
but the difference is.
And therefore, nothing inured to his benefit when it came out that, whoa, he was found not guilty. And then
Beyond a reasonable doubt, yes, sir.
Yeah, exactly. But then, that's what the counsel is saying. Well, what do you consider those things in terms of fully a chance to look at that? And it really should have brought it down.
Well, certainly, if that is what the law should be, then Congress needs to act. Because 3583E says that the court shall find by a preponderance of the evidence, not proof beyond a reasonable doubt. And it may very well have been that the jurors were sitting there, and we don't know this, and this is why we don't second guess a jury, but the jury could have said, you know, we're pretty sure that everything she said was correct, and we're pretty sure that this all happened, but is there a possible doubt? Yeah, there's a possible doubt. It's possible we could doubt that it happened. And so that's the difference between preponderance, which is the standard set by Congress.
I know what preponderance is.
Right,
I know that, but
beyond a
the
supervised.
point is that's also the difference in terms of, you really don't have much of a chance, do you? And then you got to go through the gauntlet and just really, we don't know what the judge considered either.
Well, we do.
Well, you said we don't know what the jury did. You speculated nullification, poor presentation, all those things. Can those things be on the other side too, the judicial side?
Certainly, but
Well,
we are actually, I'm sorry.
We're supposed to be, it's always pristine when it's the judge.
Right, well, but we are here today looking exactly at what the judge did in our court.
Well, what was the violation? What was the parole violation, Supervisor? What did he do in violating that? Which one? He committed a crime? He was violating a crime?
He committed a crime. It's not a conviction.
Was it?
No,
we know it's not conviction
Right.
because he was found not guilty.
Right. But supervised release requires him not to commit any future crimes. It doesn't say don't get convicted of future crimes.
So the crime was but he says that she
Strangulation.
had the keys, and
Right.
that's what he said. And the
Well,
court-
he
and
said
the court said it.
he admitted that, and the defense admitted that, too. What they didn't admit was the strangulation. They admitted that the assault occurred. He admitted on the stand that the assault occurred. The only thing that they said did not occur was that he didn't choke her. But there were pictures of bruises around her neck. There was the raspy voice. There was a not recovering from the raspy voice that took her to the doctor. There were the text messages that said, "You kicked me and hit me and choked me," and no response back saying, "No, I didn't." Typically if somebody accuses you of choking you and you're like, "I didn't choke you," that's your first response, but that's not what he responded. And if it pleases the court, I do want to move on to the sentence not being plainly procedurally
Go ahead.
reasonable, because I only have a few minutes. But the most important thing here is that when we look at what the sentence was imposed, first and foremost, the judge departed downward from the advisory guideline range. The guideline range was actually 37 to, I think it was 53 months. 37 to 46 months.
Counsel, isn't our threshold issue, even if there's a downward departure, the threshold issue is, was there a mitigation issue, legitimate mitigation issue? Was it presented to the court? And did the court rule on it? And here, there are several places in the record, it looks like to me, where the defense raised this extended supervised release. Kind of different from other cases. The government raised it, JA 744 and 745. And they identify the issue before the court at the hearing as to whether the court should consider the amount of Mr. Mills' term of supervised release, and they go on to identify how long it was. What I'm not seeing is where the court said, I mean, obviously he was aware of the issue because it told counsel to brief it. I'm not seeing where the court said, okay, I've considered this, and this is how it factored into the decision on the term of imprisonment.
So the context of raising that additional 19 months, 18 months on, or almost 20 months on supervised release was that during that entire time period that he was of good behavior, he didn't have new violations, he was taking care of his children, he was fully employed. All of these were elements that the court responded to. What the court did not specifically say is, I'm going to give you a reduced sentence because your supervised release was extended. But he did recognize.
That's what the defense asked for. I would submit to the court that he's been punished sufficiently by being on supervision. And you're saying that he's guilty, but the punishment is adequate. That is my statement. Yes, Judge. So, I mean, there's probably a lot in the record that the judge could have cited that said, you've already gotten all the consideration you're going to get, or I've taken it into consideration with the sentence I'm imposing. But the problem, it seems like to me, is that the judge never said those things.
He did not use those specific words, but at 760, he said, I studied the file, I considered all the arguments of counsel, and that have been submitted, the evidence has been submitted, and Mr. Mills' statement. And so he had considered all of those things and the arguments in furtherance of that good behavior during that time period. The other thing, though, that is that the court is not required to consider non-mitigating, just sort of neutral, if you will, factors, or is not required to specify them. The court clearly acknowledged over and over again the extended period of time or the extension of the supervised release period. But he's not required, and in fact, he's actually prohibited from considering the time spent on supervised release pre-incarceration as for credit for incarceration, and that's also 3583E3. This said without concern for the time spent on supervised release. So while the court clearly acknowledged that he spent an extended period of time, what the court did do was consider all of the good things that Mr. Mills did during that extended period of time. That he was without new violation, that he was supporting his children. But he also found that nonetheless, deterrence, the factors of deterrence and the need to protect the public were going to require incarceration for this violation. And it was based on that the judge imposed the term of 24 months. And we're asking this court to affirm that decision, to affirm the findings of the court, and to affirm the sentence.
Thank you, counsel.
Thank you.
Ms. Machina, you have some time reserved.
May it please the court. Just a few quick points on rebuttal. First, on acquitted conduct, we aren't raising an acquitted conduct challenge or a constitutional challenge, but I do think the fact that there was an acquittal drives home the point that the district court needs to be careful and get the facts right, especially when you have a lower burden of proof and less procedural protections after someone's been acquitted of that conduct. And the district court here waited for the state trial court. They waited for the jury to reach its verdict, and then once it's reached its verdict, it still decided to find Mr. Mills guilty and punish him, and in doing so, it made a clearly erroneous factual finding. And I think the government clarified, it said the district court found that there was 2 Wawa trips from the ex-wife, and that is clearly erroneous. There is nothing in the record, and the government cites to nothing, that shows she ever testified there was 2 Wawa trips. In federal court, she said there was 1 Wawa trip, and it happened after she reported. In state court, she said someone showed up on June 3rd, and then later she clarified the ex-wife showed up on June 3rd before I reported. And that's the discrepancy. The district court, yes, it took the time to consider it. It did look at it. It got it wrong. Even if a district court is taking the time and being thorough, if it gets the facts wrong, it's wrong, and that's clearly erroneous. And because it goes to the key witness's credibility, that's a reversible error. And I would like to briefly just touch on the sentencing issue. The government argues that the court said at one point that it considered Mr. Mills's arguments. That kind of boilerplate language isn't enough to just say, oh, I considered the 3553A factors and I considered everyone's arguments. It has to actually address specific non-mitigation arguments. Patterson's a good case there, right? A failure to just mention the arguments is enough. The district court here failed to mention his non-frivolous mitigation argument, and as a result, its sentence is procedurally unreasonable. If there's no further questions, we'd ask that you would vacate and remand.
Thank you, Mr. Gina. We appreciate your argument. We know that although you're the federal defender's office, thanks for taking the assignment. We appreciate that and helping us out. And we acknowledge Ms. Norman's representation of the United States. We'll come down, greet counsel, and proceed to our final case for the term. You may be seated. Thank you. Ms. Whitley?
Good morning. May it please the court, Lauren Whitley with the Federal Public Defender on behalf of Markel Smith. Markel Smith received a 4-level guideline enhancement for possessing a firearm with a scratched off or modified serial number when the firearm he pled guilty and was sentenced for possessing had a clearly legible, visible serial number that led to a traceable firearm. Mr. Smith pled guilty and was sentenced for possessing a machine gun in violation of 18 U.S.C. 922-0. The gun in question had 3 serial numbers. 2 of the serial numbers were modified, one on the chamber of the gun and one underneath the muzzle on the frame of the gun. The 3rd number, however, on the barrel of the firearm was completely visible, completely legible, unmodified, and was used to successfully trace the firearm in question. The guideline at issue, particularly for, of course, Mr. Smith's second issue before this court, is U.S. Sentencing Guideline 2K2.1 B4Bi, which states that someone receives...
Are you still presenting a Second Amendment argument on 922-0?
I am, Your Honor. I'm happy to answer questions on that issue. I know that there is a per curiam opinion under Taylor from this court that has denied that issue, ruling essentially that machine guns are not weapons considered in common use and therefore not within the gambit of the Second Amendment protection. But we are still presenting that argument. I was jumping ahead to the second issue, but I'm happy to answer any questions the court has.
I was just going to note in our Bianchi decision, which had some degree of disagreement, it appears to me that all 15 judges agreed that the machine gun regulation was permissible.
Yes.
Okay.
Yes, I mean, I would note, Your Honor, to the extent that the court is looking at the facts of this particular case, Mr. Smith here possessed a machine gun conversion device that was attached to a handgun. And I do think that's slightly different when considering the self-defense perspective that certainly the United States Supreme Court is putting forward under Bruin and those concurrences and dissents in Rahimi. We have a handgun that is a fundamental firearm for self-defense. And so I do think that this presents a slightly different position than perhaps I believe the assault rifles in Bianchi or in Price dealing with a scratched off serial number, as well as in, I believe, Miller, the U.S. Supreme Court case that speaks about a shortened short barrel rifle. So we would argue that this is a different situation. And just kind of wrapping up that point, the machine guns are also now at this point, I think, I quoted some statistics in our brief in the district court as well we did here before this court. There's almost 750,000 machine guns now in circulation. Legally, I think the district court actually clarified that in its denial of the motion to dismiss, stating that there are almost a quarter or over 250,000 that are in private hands of machine guns. So that common use kind of categorization, we argue, is erroneous, and that the Second Amendment does protect the right to possess such a firearm. And then, of course, then the burden shifts to the government to establish the history and characteristics are consistent with that type of regulation. So we stand by the briefing arguments. I'm happy to answer any other questions on that particular issue, but I was kind of moving forward to the second one. So again, the guideline for that second issue presented here that we're speaking to states that someone does receive this 4-level enhancement for any firearm had a serial number that was modified such that the original information is rendered illegible or unrecognizable to the unaided eye. And the goal that's stated in commentary to this guideline, and certainly in the case law interpreting it, is to render punishment and deterrence for the untraceable firearm, the trade, the sale, and the possession of the untraceable firearm. And it's really the guideline language here, the second phrase, which the district court here in denying this objection focused really on that first phrase, but the second phrase is at the heart of the guideline and what it aims to punish additionally by this enhancement, such that the original information is rendered illegible or unrecognizable. Here, Mr. Smith possessed a firearm that had a clear, unaltered, unmodified serial number on the barrel of the gun. It wasn't scratched in any way. The court certainly has documentation in the record about what the serial number looked at. It didn't require any additional forensics or microscopes or acid to view the number in question. And of course, while not necessarily indicative of the application of the guideline, the gun was traceable, and it was traced by the ATF agent. I would compare it kind of similar to having a book, where you have the title of the book in a number of places, on the spine, on the cover, on the inside page. Certainly, we've all had books where the spine is cracked and broken and you can't read the title. Maybe the inside page is ripped out, but you still have the title of that book on the cover or inside the book itself and other places. You know what the book is. You are able to identify it. And that's what we have here with Mr. Smith's firearm. In particular, I think
Let me ask you this.
Yes, ma'am.
Real quick. So you, the weapon, I understand the law and the regulations to say that the serial number is to be printed on the frame or the receiver, and here it's printed on the severable part of the gun. Does that change your argument regarding the enhancement?
I would say no, Your Honor. I would just highlight that this particular firearm had what appeared to be 3 serial numbers on it. One was on a plate. It appears these Glocks have a plate underneath on the frame of the gun, underneath where the muzzle is. That was scratched off or modified. There was a serial number that was on the chamber or the slide of the gun, obviously not the frame identifiable part. That was scratched off or modified, and then the one that was unmodified in any way was also on the slide of the gun underneath of it. But Your Honor's question, we would argue it doesn't change our position as long as there's a serial number such as here that is usable, legible, visible, and traceable, that the guideline enhancement should not apply. And I would certainly note that the regulations, I think Your Honor is referencing, minimally requires 1 serial number on the frame of the gun. And so certainly we have a gun here that has more, and there could be a situation where a firearm the manufacturer for whatever reason could put 10 numbers on the gun, 10 serial numbers, and 9 of them are legible and 1 of them is scratched off or modified. And certainly our position would be the guideline should not apply there either. So just kind of as a hypothetical example. One of the arguments too that was raised both in the district court and here are the changes that were made to this particular guideline in November of 2024. The commission imposed changes primarily to resolve a circuit split about how legible.
Is part of your argument that the guideline is unenforceable because if there are multiple serial numbers, all the same, and 1 or 2 out of 3 or however many there would be are legible, that there's no authority to adopt that regulation?
I'm sorry, Your Honor, I could just ask a clarifying question. Authority for the Congress to adopt a regulation imposing, if the court, I'm not sure I understand the court's question.
Or here it's a guideline, isn't it?
Yes.
Well, that's what I'm asking. Is part of your argument that there's no authority to adopt this guideline where there are of multiple serial numbers, at least 1 that is fully legible?
No, I mean, I think the Sentencing Commission and Congress certainly has the authority to adopt a guideline that makes clear if they intended, and the language would be, right now it says any firearm had a serial number. Certainly they could have said any firearm had any serial number, which would make it extremely clear that Mr. Smith's position would be much more difficult, because then they're saying if there's any serial number, even if others are legible, that has been modified, this enhancement applies.
So the bottom line of your argument would be that the guideline is legally adopted. It's just a question of what it means because of the change in the language?
Yes, yes, and how it applies to this particular factual scenario, Your Honor. And of course, our position is that here, looking at the language of the guideline and what was presented, this enhancement did not apply. So yes, sir. I think the other thing I would just highlight too is that we're talking about, of course, a situation with a guideline that has no mens rea. There's no knowing element here. It's a guideline enhancement, which has a lower standard of proof. There is a criminal offense for possessing a firearm without a serial number. There's a criminal offense for possessing a firearm that has a modified serial number. That requires those additional levels of proof and constitutional protections that weren't afforded here. So certainly, even, or more particularly in this situation, when you have someone accused and pled guilty of a crime, and you're looking at a strict liability guideline, then the language matters of the guideline, and how it's applied certainly matters. And in this particular situation, because Mr. Smith had a clearly legible and traceable serial number on this gun, it was error to apply this guideline. So for that particular issue, we are asking the court to reverse the sentencing, remand for a new sentencing with corrected guidelines, and we stand by our remaining argument for the first issue on the Bruin motion to dismiss. I would like to reserve my remaining time for rebuttal, if I may.
You may.
Thank you.
Thank you. Mr. Sawyers?
Good morning, Your Honors, and may it please the Court. Reed Sawyers for the United States. To start with the Second Amendment 922-0 issue, as Judge Agee recognized, every judge on this court agrees at the least that the dangerous and unusual weapons tradition at Step 2 justifies a machine gun ban. So I think the most straightforward and most robust manner for this court to resolve this issue is to say whether addressed at Step 1 as a matter of common use, or whether addressed at Step 2 as a matter of dangerous and unusual weapons. Machine guns are dangerous and unusual weapons not commonly owned by the public for lawful purposes, and therefore Section 922-0 is constitutional across the board. I'm happy to address any questions the court has on the Second Amendment issue, and if not, I'll turn to the guidelines enhancement issue. The text of the guidelines enhancement is unambiguous, but even if it weren't, all the other considerations this court looks to, precedent, purpose, and policy, point in the same direction. The district court here correctly determined that so long as one serial number is not legible to the naked eye, the enhancement applies. Start with text.
But you would agree, the district court, and I think the attorneys below and the government, there was a significant amount of argument over if it's a or any. Wouldn't that lead to it being the suggestion, or I guess maybe, is that there is some, that it is ambiguous?
So I think you're getting at the rule of lenity, Your Honor. As my friends conceded at J275, the rule of lenity only applies when a provision is grievously ambiguous, and as the Chapman case they cited makes clear, it only applies when the provision is grievously ambiguous after you exhaust all the tools of statutory construction.
Well, when you consider the purpose of it and the ambiguity, maybe it is grievous. The whole idea is that we don't want people having weapons that are not traceable. Here, if you have three and two are obliterated or somehow changed, but one is clear, then that would, interpret in the way you would undermine the purpose because it's traceable.
Your Honor, one purpose of the enhancement is punishing the possession of completely untraceable firearms, but as the St. Hilaire case from the Second Circuit makes clear, the enhancement also aims to punish the possession of weapons that are more difficult to trace, and as this court recognized in...
Well, why do you all say, because I saw that argument in there that where you said that it's less, one alteration makes a weapon less traceable. How is it less traceable here if it's the same number, just because of the one alteration?
So at J311 to 312, the record is clear that firearms parts on Glocks are severable. You can take the slide, you can take the barrel, and you can take the frame apart. And I think St. Hilaire is clear that, and I'm going to read you the exact quote, "A gun with an indecipherable serial number on a single interchangeable part is just a swap or two away from being untraceable. And thus, the enhancement's policy extends to firearms that are more difficult."
But here it isn't a question over one particular part. The gun's intact. So if two of the three serial numbers were fully intact, would that make any difference to your argument?
No, Your Honor. Our primary position, which is the position that has been adopted by all the courts of appeals addressing the pre-2024 guideline, is that So two of them only addressed whether the serial number had been obliterated on the frame. Here it's obliterated on the frame, which is the part required by regulation to have the serial number. The rest said that the obliteration of a single serial number, no matter where it is, suffices. And I think it's really important to look at Sands, the Sixth Circuit decision, and St. Helier, the Second Circuit decision, because we don't need to guess at the Sentencing Commission's purpose here, because in the text of Amendment 828 itself, they spelled out their
But the
purpose.
Sentencing Commission has told us in 2000, as far back as 2006, that their concern is traceability, that the purpose is traceability. I mean, that's the purpose of the enhancement, is traceability.
And as the St. Helier case notes, it's not complete untraceability that's at issue, and that's only confirmed by the recent amendment twice over, because the recent amendment does not require that the firearm be untraceable through scientific means, only that the serial number not be visible to the naked eye. And I think it's really
But
important.
here it is.
Wha-
I mean,
wha-
it's very visible.
But to quickly return to the St. Helier point, in both Sands and St. Helier, the Sixth and Second Circuits, where the Sentencing Commission drew this standard from, both of those cases made clear expressly that the enhancement applies if one serial number is illegible. And that's so because it serves the severability purpose, and the Sentencing Commission, in the text of Amendment 828 itself, expressly said it was adopting the Sands standard, which it called out by name that case, and the St. Helier standard, which it called out by name. So it is inconceivable that the Sentencing Commission, in expressly adopting the Sands and St. Helier standard as to the degree of legibility of the serial number, meant to sub silentio overrule the other half
So
of those.
let's assume two of the serial numbers are fully legible, and the first letter or number on the third iteration of the same serial number, that's marked out. But the rest of the serial number's still there. What
Ye-
happens there?
So we would say that the third serial number, and I just want to make sure I have the hypo correct, so if I say anything that suggests I'm not understanding, please correct me. But there, the third serial number would not be legible to the naked eye because you can only see one of the letters. And it's true that in some sense you might be able to guess or infer that it's the same serial number, but you have a lot of uncertainty there. And therefore, because the third serial number is not legible to the naked eye, and it is a serial number, then the enhancement would apply based on its plain text.
So what's the logic in that situation? I mean, clearly you've got the same number in two other places, and the third number has everything that's the same except for the first letter. I mean, there's no doubt that you can trace the firearm the same way as if there were three fully legible numbers.
The primary logic is the severability logic discussed in St. Helier, but it's also true that this court in Harris made clear that there are purposes to the enhancement even beyond traceability. There are other law enforcement benefits. And to use an example from a recent district court case I've worked on, the agent there was able to confirm based on pictures on the defendant's phone that he previously possessed the same firearm because he saw pictures of the defendant holding up that firearm, and in those pictures, one of the firearm serial numbers was visible. If that one serial number had been altered or obliterated, the agent would not be able to perform that comparison.
But, I mean, I think Whitley made a good point. I mean, we're told that in the commentary that state of mind, I mean, it seems like you're getting into state of mind issues, and obviously there's criminal statutes where you can charge if there's a way to show that somebody obliterated, or if that's what you're trying to do is punishing the defendant for being the one that obliterated the serial number. But here, I think the Sentencing Commission has been very clear that it's traceability.
Respectfully, Your Honor, all of the cases to address this issue, including the St. Helier case on which the Sentencing Commission based the 2024 update, made clear it's not complete untraceability, and I think that's the critical aspect.
But you would agree that the sentence, in the commentary, it also says that for purposes of the enhancement, the commission is saying we are not looking at state of mind.
I think what you're getting at is whether there's a mens rea requirement to apply the enhancement. And as my friend agrees, the enhancement does not require a knowing mens rea, whereas 922K does. Is that what you're
Yes.
getting at, Your Honor?
Yes.
But I don't think that's relevant to the issue that St. Hilaire and Sands expressly addressed, which is how many of the serial numbers need to be altered or obliterated. And because the policy behind the enhancement is assisting law enforcement and preventing firearms that are more difficult to trace, the policy behind the enhancement does apply. But
Let
again,
me ask you this question. There's a different hypothetical. What if there are two serial numbers, both of which are on the non-severable part, and one is obliterated? What would be the situation there?
so just to ensure I have the hypothetical right, if there were two separate serial numbers on the frame of the firearm,
That's right. And one was obliterated, but one was just pristine. You could read it clearly.
so first I would say I'm not aware of that circumstance ever
You know
arising.
why? That's why it's a hypothetical.
Yes, I think our primary position would be that because a serial number has been altered such that it's no longer legible, and that is the plain and unambiguous text of the guideline, because a serial number is no longer legible, that it
But
would
you gotta be
apply.
very careful now. The Second Amendment still applies now. You may be okay with Bianchi. I'm not saying one or the other. But the whole idea, though, is that you're limiting people's right to have weapons right in their home. So you purchase the gun, you know there's a law that says you can't have a gun that's not traceable or doesn't have a serial number on it, but you buy it and say, well, one is gone, but one right here is clear. I mean, this ought to be okay because it's traceable and it seems the law. Isn't that impinging upon someone of the Second Amendment right there in terms of, because this is not just, well, we look at this just for the person who's crime, but we're talking about people who otherwise, if you go in their home for another reason, like just to check on their stove or whatever, and you say, oh, look at this weapon here. You only have this. Yeah, I got it, but it's clear here that you can read what it says. Don't we have a little problem there if we go as broad as you want us to go?
So I think there might be different Second Amendment concerns at play with the statute, 922K itself, but this court made clear in Simmons, and this is an analogy, but let me quickly explain it. There, the defendant possessed an NFA firearm, a National Firearms Act firearm, like a machine gun, and this court said that because the defendant there agreed that nobody could possess a National Firearms Act firearm, he couldn't challenge on Second Amendment grounds the sentencing enhancement applicable for him being an unlawful user of controlled substances. So I think here, because the defendant did not have a constitutional right to possess a machine gun, as he all but concedes, that you don't engage in a further analysis. I agree that in the 922K context, your hypothetical about the two serial numbers printed on the frame might be more difficult. To be blunt, I haven't thought about that issue a lot, so I can't provide a firm position there, but it's simply not implicated here, both on the facts.
Here, he wasn't charged with the possession as a crime, separate crime. He wasn't charged with the possession of a firearm with an obliterated serial number. This is for sentencing purposes.
Yes, and I do want to be clear that there's no reason to think on the text, rather than on the Second Amendment, that 922K and the enhancement are necessarily coterminous and need to be interpreted together, because as my friend noted, 922K has a knowing mens rea, where the guidelines does. So it's a different question whether 922K applies when only one serial number is obliterated. This wasn't in the briefing because it obviously didn't come up, but the few cases I found on that suggest that 922K would apply, the statute would apply when one serial number was obliterated, but this court does not need to decide that here today because the guidelines enhancement and the statute are not necessarily coterminous. If the court has no further questions, we ask that the court affirm.
Thank you, counsel.
Thank you.
So you have some time.
May it please the court, I don't have additional argument, but if the court has additional questions based on the argument presented, I would be happy to answer them or address them. Thank you.
I note that you're also a court-appointed sign, but of course you're with the the Public Defender's Office, but thank you for taking the assignment. We appreciate it on behalf of the Fourth Circuit.
Yes, sir.
And we acknowledge, of course, Mr. Saw's representation of the United States. We'll ask the clerk to adjourn the court, sine die, then we'll come down and greet counsel.
This honorable court stands adjourned, sine die. God save the United States of